The GST case law compounding amendment November 2024 provides a crucial insight of a landmark judgment of the High Court and Supreme Court on various concepts issued by GST. The key highlights include which is the first appeal authorities in enhancing the tax demand without adhering Section 107 proceeding if retrospective cancellation GS registration without reason is valid. The court deliberates the imposition penalties in Section 129 of discrimination of incorrect e-filing of billing address on the absence of means RIA and confirmation of demands based on the unmentioned SCR requirement and suspension. A significant judgment is invalidated in order passing against a decreased portion and clarifying the belated filing of bill repetition and vagueness. SEN without the prior notice, another issue of addressing the whether the single SEN should cover the multiple tax period and if uploading notice and the view additional notice and order, TAPS offers and legal communication comprehensive further explores the illegality of blocking electronic credit ledger to whether the negative balance of the negative to detail the order section 7374 of supplement summary order. In other notable decisions of the in-court instance of accordance of delay appeal to initiate the confiscation section 130 of excess work and affording the taxpayer additional opportunity of post rectification proceeding. Legitimacy of the order under the issue of the board statutory timeless and leaving the interest on the availing of but unissued ITC. As an address, addition of the High Court entertained the petition challenging the Echo number 12/6/2024 GSC's mandate the proof of credit reversal for the post-sales discount. Further, the court ruled ITC eligible in the absence of the genuine transaction proof and maintained the debtor protection along a CN alleging suppression of Section 74 provision. This ruling shows a robust understanding of the procedural substantial intervention of the GST. Whether first law appeal has a power to enhance tax demand without following the procedure laid down in Section 107. No, the Honorable Calcutta High Court Hindi Kumar Das with the state of West Bengal (ORS) said that the impugned order has not and following procedure discrimination 107 Act. The Honorable High Court noted that the petitioner filed an appeal against the adjudicating authority confirming demand tax of 2 crores and imposing a penalty of 41 lakhs. Appellant authority was required to consider the asset to whether the tax liability fixed by the adjudicating authority 2 crores is correct and whether the penalty is levied on the total amount of 40 lakhs. However, the appellant authority, while passing the order, has a sudo motu enhance the tax liability on the accounts payable by the appellant without following the procedure section 107 Act. However, the order passed by the appellant authority to the extent is not tenable in law, therefore liable to set aside. The order passed by the appellant authority as well as adjudicating authority set aside and matters are remanded to adjudicating authority for the fresh consideration. The Honorable High Court on the order of appeal shall file supplementary to reply to the allegation the show cause notice arising all contention and all dealing with the effect of closing order 2207/24 with the period of 6 weeks for the date of receipt of the server notice of the copy, after which opportunity of a personal hearing to afforded to the authorized presentation for the appeal to fresh order for past merit of the authorized by the law. So, 10711. Yes. Author come a Latin name referee motto in penius means a change the worse. Other words, a person who has appealed against the adverse order cannot be left with a greater grief that they suffered earlier. While the principle is extremely admitted, the status of law of judicial authorities expressing provision of Section 107 appears to deliberate department in order to workable Section 107, which permits updating the demand, obtaining the demand, not the readjustment of by the appellate authority. After all, the provision of reformatio in pursuit in the nature of fair procedural consideration inherit the principle of natural justice. It is not the procedural guarantee but the principle of equality itself. Apex Court of Justice Nexo Limited CC 2015. Further, the expression of the second provision all credit the refund does not claim the indication of the pre-existing demand, yet the appeal authority may allocate the new demand which is not possible due to the exclusion of the appeal authority for the definition of adjudicating other section 24. The registration can be cancelled by the retrospective date without assigning any reason. Now, the Honorable High Court in the case of Suresh Chandran Gupta, Union of India, passed an order cancelling GS registration retrospectively due to a lack of reason and failure to mention the proposed action of the show cause notice. The Honorable Court noted that the impugned essentially is cryptic and does not clearly set out the reason as to why the petition GS registration was proposed to be cancelled. It's merely reproduction of a statutory provision section 229 2E of the GST Act. For enabling the proper officer to cancel the taxpayer GS registration, it is opted to means for fraud. willful misrepresentation or suppression of the fact. The impugned essentially does not set forth the details of the nature of alleged fraud. It is also deemed not incident that is statement which is alleged to be willfully misstated of any fact, which is alleged to have to be suppressed. And the Honorable Court said that impugned essentially met the requisite standards of Holocaust notice. The Honorable Court observed that the impugned cancellation order has to be passed in violation of the principle of the natural justice, and therefore it is liable to set aside direction of petitioner registered in the restored tribunal. Author comment: cancellation of registration far-reaching consequences given the legislature has specified explicit delinquencies under Section 29(2), which is no violation of principle and natural justice, cancelling registration without the following due diligence law. Section 155 CGST Act places a burden of proof eligibility to crime only on the taxpayer. For otherwise, the burden of result of revenue making the allegation and not in the registered person offering application. The burden of proof is not discharging by making the allegation. The burden of proof is discharged only when the amount of evidence commensurate with the nature of allegation made in the producing and appended to the notice. Allegation of severe wrongdoing require proportional substantial evidence. Evidence is not extracted on the books of account and statement taken on oath or letter received from the other person of department. So, on oath. Books of accounts. Evidence did not attract the books of account statement takes on both the letter received from other department. Letter received from other department. Okay, the evidence is in that which provides something solely the fact the taxpayer is not found the principal place of business during a department visit. Solely the fact the taxpayer is not found in the principal place of visit without any corroborative evidence or material record. It is allegedly deeply rooted in the incomplete investigation based on the surmise, conjunction, and assumption is unable to bring the home allegation linked to the taxpayer. A similar addition of the Jai Kumar Sudarshan Enterprises to the Delhi High Court. However, the penalties under Section 129 can be imposed for discrimination relating to the address mentioned in the EV bill when the mens rea does not exist. Oh, no. Honorable High Court of Allahabad, Ayutthaya Electronic Store, State of P. Squarely impugned the order and allowing the reputation. The Honorable Court noted that the error in the EV bill where the place of delivery is mentioned as Chantapur instead of Aligarh would have been due to a human error while filing the form. Further noted there is no finding of authorities that the petitioner had means as an intention to evade tax. Even during the prosecuting report, there is no argument made by the state that the petitioner intended to evade tax. Honorable Court really relied on the earlier decisions made by Nancy Trading Company, State of UP, where it was held that the absence of any specific finding regarding a mens rea. Mens rea. Section 129 of the GST Act should be initiated. Since there is no finding of lead regarding menstruation in this case, the impugning order dated 13 September and 21 August of 2019 would not be legally substantial on the consequence. Honorable Court squares both the impugning order and allowed petition. Author comments. Author comment. Okay, as per section row, the clause number 64, 30, 2019. 2019 August, September 14, and gentle penalty section 125 of GST Act must be imposed in a minor breaches or discriminatory. The author considered the opinion all the discriminatory about the movement of goods except the fatal errors like non-accounting of transactions or supply of goods accounts are treated as a minor discriminatory. No penalty section 129 and the GST Act. What Act? CGST, SGST, what Act? Under section rule 130. 38A of GST Act. Mercia exists to prove all errors omission have been treated as a non-fatal error and no penalty under section 120 imposed. Similar judgment has been allowed. Allahabad High Court, Jindal Pipes Limited, and Deputy State Tax. This court set aside the order imposing penalty under Section 129(3) UP GST Act of the reason for defective was a technical nature only and without any intention to evade tax. The demand can be confirmed based on the requirement non-mentioning SNC. Now, Honorable High Court of Madras in case of TVL Lithuania Metals Sales LLP versus Assistant Commissioner aside the impugned order to remand the matter for reconsideration. Honorable Court noted that the show cause notice addressed by tax proposals. Two tax proposals. The first issued was a claim of input tax credit respect of alleged illegible commodity as per the section 17 class 5 of GST. The second issues on the claim of ITC for supplies for cancelling cancelled order from the cancelled dealers who do not activate tax dues. Honorable Court observed that the first due impugned order did not include any finding or discussion, and for the second issue, taxpayer was confirmed based on the lack of evidence on the movement of goods, as well lawyer received weightages which were not mentioned in the show cause notice. Honorable Court, under the impugned order, could not sustain because it does not address the first issue and require documents that were not specified in the show cause notice. And the Honorable High Court set aside the impugned order. Remand the matter for reconsideration. Petitioner allows submit additional reply by relevant document regarding the movement of goods within the 15 days of the receiving a copy of the order and act the respondent to prove the reasonable opportunity to be petitioner, including the personal hearing issue of the fresh order within 3 months of receiving the additional reply. When a self-assessment is challenged, the burden rests on the revenue making the allegation, not on the registered person suffering on allegation. Burden proof is not discharged by making the allegation. The burden proof is discharged only when the mounting of evidence is commensurate with the nature of allegation made in producer of appendant to invoice. Allegation of the serving a wrongdoing require proportional substantial evidence. Evidence is not extracted from the books of accounts and a statement taken on both evidence in the prove something. Section 155 of CGST Act place that the burden to prove regarding eligibility of credit only on the taxpayer. One is shown all the consideration section 166 for 166 taxpayer burden is discharged and now shifting the department of prove case. In the instance case, the petitioner could have disputed the allegation stating them being trade. If the outward supplies are accepted to the genuine when the inward supply has been genuine. It is inward supplies in ingenuine and outward supplies accepted to be genuine. Then the allegation is deeply rooted on the incomplete investigation and summarized surmise, surmise and conjunction. Revenue cannot approbate and probate the same issue. Approbate and probate. The taxpayer must have allowed the revenue to prove the case and the absence of evidence support of allegation self-defending. Further, the adjudicating authority is barred of improving the grounds of notice. Improving is alter the quality of control without substantial the two same is within the bar section 75 and 160. 157 and section 160. Well, the order under GST is passed against a decreased person. No, Honorable High Court Kerala as Bino Abraham, the state tax officer, our petition and quashed the order passing against a decreased person, held the order passed against a decreased person and nullified. Section 93 of CGST rules that permit the continuance of proceeding against a legal hire but does not authorize the culmination of proceeding against a decreased person. Culmination. The tax authorities direct the continuing proceeding and against illegal hire of issuing notice of the pension who hold the office of attorney or other legal rights. Honorable Kerala High Court observed that the provision section 93 of CGST permits the continuance of section 93 permits the continuance of proceeding against illegal hire for the decreased person. The case of business has been discontinued. This unauthorized continuance and culmination of proceeding against a decreased person. Therefore, impugned order is nullity and rightly condoned by the learned counsel appearing for the petitioner. Honorable Court decide which the permit with respect to allowing an impugned order is quashed. The respondent was permitted to continue with the proceeding against a legal hire of the decree, since the petitioner, who is one of the legal hire of the decreased, also hold the power of attorney on the other legal hires. The respondent may issue the notice of petitioner completing a proceeding. Such a notice of petitioner will be deemed to be proper notice and to the other legal hire as well. Author covered all the proceedings against the dead persons and non-esto the lives of the order of 22 Rule 1 of Civil Code of Civil Procedure already that produced in the front story. The death of plaintiff or defendant should not cause the suit to abate the right of sue services. Due to the death of a person, all the proceedings against such a person stand abated. So away that closed. And further, section 169 of GST service on the notice order the communication against such persons neither validity served to such person nor it must be accepted on the accounts of such person of which other person. Apex Court, CIT, SAN, Stream Navigation Company Limited is well settled that no mandates will be issued unless the applicant has been a distinct demanded on the appropriate authorities for the very relief, which seeks to ensure the mandamus and that be enforced by mandamus. Enforced by mandamus. Mandamus. Further, it is considered opinion of the author. No proceedings shall be initiated against a legal hire of the decrees, as it exists no provision in the GST law that mandates the initiation of such proceeding against a legal hire of the decreased person. Contrastingly, the Income Tax Act 1961, Section 50, 110 to empowers the revenue to initiate proceeding against a legal hires of the decreased person. Section 93 of the CGST 2070 covers a situation where liability is determined under the person and such person dies thereafter. Where no liability is determined by the following the due process of law, there cannot be any proceeding against a legal hire of the decreased person. Whether writ petition can be filed belated on citing a vagueness in the SCH without raising any grounds of the action. Now, Honorable Supreme Court of Bombay, Viswat Chemical Limited, Unity. The dismissal of writ petition was held that the petitioner should have taken all the grounds before adjudicating authority, and if agreed, and should have availed the alternative remedy of appeal. Honorable High Court of Bombay noted that the impugned SEC is not all the work, but rather contains all the material particulars, giving a petitioner a very clear idea about the case that they are required to meet with, and therefore the petitioner must know serious grievance and alleged vagueness of response notice. Allegation of vagueness can afterthrow besides being frivolous, frivolous, frivolous. Frivolous and is raised on the avoid resorting alternative and remedial appeals against the petition. The further observed that the petitioner have also treated and take a chance in the matter. Upon receipt of the impugned SEN, the petitioner filed a detailed reply in April 21st or 24 April 2018, and the employee however seriously alleged vagueness in the impugned SEN. The Honorable Court relied on the case of Whirlpool Corporation registered trademarks Mumbai, and the Honorable High Supreme Court explained that the writ petitions may be entertained against the show cause notice, and the petitioner seeks enforcement of any of the fundamental rights where there is a violation of principles of natural laws, where the order is procedure and hold within the jurisdiction. The violence of the act is challenged. The Honorable Court held that the order is institutional petition. The parameter Honorable Supreme Court is laid on the Whirlpool Corporation and been satisfied. The writ petition was dismissed with a cost of 5 lakhs payable to the petition of the Maharashtra Legal Service Authority within 4 weeks. Authors comments: not everything that work and different difficult to comprehend can be called arbitrary. Arbitrary demand is certain minimum level of understanding of the current before the capable of declaring something arbitrary. The defense that relies on arbitration based on the burden of demonstrate the exact level of unintellectuality of the allegation, the notice that is going to root of demand and destroy it completely. It is common to find the demand in the notice of arbitrary. It is important to note that allegation in support of the demand may lack some essential ingredients, and it may offer a ground to assign the notice of grounds and arbitrariness. Section 160 may rely upon the educating a revenue of overcome allegation. The arbitrariness, what is this? Arbitrariness may be advanced and defense with great circumspection because force and arbitrariness remains notion more to be said by the way of defense and arbitrariness end in the further defense. Other grounds, additional arbitrariness is a contradiction of such one. Section 35 of Common Civil Code 1908 gives the direction of the court to impose a cause and safeguarding false and vexatious claim and defense before the court. In this instance, the Honorable Court heavy the petitioner to impose cause of 5 lakhs to discourage such practice and approach the red court so without satisfying the fundamental ground of maintaining petition. Whether a single SCN can be issued by multiple taxpayers. Now, the Honorable Madurai High Court, Minta Limited, with a Joint Commissioner GST Excise said apply the branch of SCN issued on various taxpayers to split the SCNs of every taxpayer. All the petitioner awaits benefit by the amnesty scheme. What is amnesty scheme? Proposed to the launching during November, it would be waive interest as well as penalty of tax liability. The Honorable Madras High Court observed that as a no willful misstatement made by the petitioner, hence the impugned SCNC was without jurisdiction and two-wheeler seaters manufactured by the petitioner appropriately classified as HTC 904 was not under HTC 84. Honorable Court made a Titan Company Joint Commissioner. The Madras High Court said a bunch of SEN issued was a separate years. The Honorable Court noted the deposit amount made by the petition of tax liability extend to 124 crores. 74 lakhs is not shall not be claimed to be refunded. If a response is issued and the SCN 6 assessment year, the petitioner will not raise the issue of limitation. However, the petitioner intention is that only in the event of separate SCN being issued, the petitioner will pay the tax liability and avail the amnesty scheme, which is proposed to be launched by the respondent by the November 24 and would be benefit to waiver of interest as well as penalty. The decision rendering silent which is considering GST involves matters that transcend financial year with amount. The ITC account 1 year subsequently condition claiming the fulfillment of tests. For in another area, it is considered the option of the author, which aspect is not considered and the judgment is distinguished on the many levels and have any force laying down good present in GST. The issuance of single SC in multiple years is not something that can be placed to highlight. Exactly, taxpayer is aggravating such scenario, and the decision itself gives an liberty to respond to issue free notice. This condition. This further circulates 27 December ensure no prejudicial cause of taxpayer and was never discussed. Whether uploading essay and viewing additional notice in order tab is sufficient communication notice. No, Honorable Delhi High Court case Blabo Rana, proper officer GST, held that the showcase notice uploaded under the degree of view additional notice in order, which of view notice order given GST portal was designed on sufficient communication SE and subdivision. Honorable Delhi High Court, AE cardiopathy solution and the further alleged in the East Coast Construction Limited Assistant Commissioner. The High Court of Madras noted that communication placed on the viewing of our view notice and orders and view additional notice and orders. The Madras High Court directed the response arising on the position information to separates as a petition view additional notice and view user services are not under the heading view notice of orders. The further Honorable Court observed that GST authorities were addressing the issue and have redesigned the portal to ensure the view notices and view additional notice tabs to place under one heading but SEN was issued to the petitioner prior to change. Hence, the impugned order set aside that the matter was relevant executive authority considering as fresh. And, Section 169 GST 14 different way modes of serving notice. Decision, order, summons, notice, other communication. Care must be taken by the authorities, not a simple pick and choose any option. They are the best possible option to choose by which is mostly likely to reach the intended notice. The notice or any other communication would be treated on the serving until the reach the intention notice. In the author's considered option, it is immaterial whether notice is uploaded on the view notice or order tab, a view addition notice tab. The only aspect to consider whether or not the intention notice are served to the intended nominee. If not, then the service of SAN must have been displayed and must be allowed to revenue charge the burden regarding the service of agency. This discharging of elementary burden due process under the law is abused by the HSN serving quitting as the judicial review. The revenue department can block electronic credit ledger by making negative balances. No. So, Honorable High Court in the case of BPW Metals and Alloy Union of India is invoking the Rule 86A for purpose of blocking input tax credit by justified concern authority of any of the authority. 86A. Empowering the law of the prima facie opinion based on some cognate material of ITC short to be availed based on the fraudulent transaction like fake, bogus invoice, etc. However, the substantial satisfaction would have based on some credible material information also should be supporting a supervisory factor. The Honorable High Court noted that the plain pursuit of the imposed order under the challenge is shown the Revenue Department has made negative credit in the electronic credit ledger a petition otherwise not permissible, and this permissible is only block the availment of ITC whether as a credit or petition. The Honorable Court relied on the judgment of the Gujarat High Court, Same Alloy Limited, where the D held with the credit is fraudulently availed by place. Appropriate proceeding under the proceeding of section 73-74 CGST Act, the case would be initiated. Further, Rule 89-86A, the GST rule is not a rule that provides debarring the registered person from using facility or making payment to electronic credit ledger. In this intention of the disallow the further deputy the credit of electronic credit ledger, the text of rule must be entirely different. The Honorable Court stated 86A of CGST empowers a proper officer to disallow debit of electronic credit ledger for the amount equivalent to the amount claimed has been fraudulently availed. And if no input tax credit is available in the credit ledger, the rule does not provide insertion of negative balance ledger. Honorable Credit Court as application of part of Revenue Department passing order of negative credit as a contrary of Rule 86A of CGST. Author and comments. There are only 5 reasons when the preemptive emergency rule of Rule 86 moves. If there is any other reason not failing, then the use of exceptional power where the contrary of law, blocking the input tax credit, where the vested and unsophisticated rule, nature of property and registered person, where institution thief. These passion protect the interest of revenue not only to authorize a bypass the law, it advisedly called the reason to believe that commissioner may be authorized power, Rule 86A to pre-emptive action. Empty action by however decision of commissioner or any other authority officer, it's not an appealable decision, therefore it's not specific rule 121 factor.